Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome into an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder of Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here, he's a former Army JAG and worldwide court-martial defense attorney. He's tried more than 240 court-martials to verdict and litigated more than 350 military cases all across the United States, Europe, the Pacific, and the Middle East. Today's episode, we're going to be talking about one of the most overlooked pieces of building a winning defense, and that's truly understanding people, personalities, motives, body language, pressure, stress reactions, and why preparing witnesses is every bit as important as preparing legal arguments. Joseph, it's good to see you. I'm excited to talk about this topic. So let me ask you at the high level, when you are preparing for a case, what's the moment you start paying attention to the human factor, let's call it, like the personalities, the motives, all these emotional dynamics that are surrounding the allegation?
Thanks for having me again today, Mike. Really, it starts at the outset when we're speaking with a potential client and then they become a client. When I first start speaking to someone that is looking for my legal services, I'm already analyzing how they process information, what their output is, how they synthesize that information and then spit it back out to you. I tend to ask very direct questions and I'm looking to see how they respond to it. And so when they become a client, it's the interview process between me and the client, my staff and the client, and then the narrative that we ask them to write, and then their response to my questions based off of what they write. It's really important to get to know your clients, to understand how they think, how they process information, what motivates them, what are the stressors that they have in their life, current work stressors, family stressors, those sorts of things. So oftentimes I'm not a friend to my clients. I'm their attorney, and I make sure they understand that boundary. But it is vitally important to get to know the client so that you can best serve them.
Let's talk a little bit about when you're preparing them for trial, right? What's something that kind of tips you off early on that tells you, okay, I'm going to have to lean in a little bit more on the preparation with this witness?
Sure. So if it's a client or a witness, one of the things that we're looking for is what are their nonverbals telling you, right? So what are nonverbals? What their eyes do, what their hands do. Do they have a nervous tick? Is their leg always going 90 miles a minute? Do they take longer than usual pauses? Pauses to think about what you're going to say are not a bad thing. In fact, a lot of people are nervous about public speaking because they think if they're pausing to say something, they think that it looks bad, but it doesn't. So how comfortable are they in their own skin? Do they project well when they speak? What their outward effect is? Those sorts of things. So their interactions with me, my observed interactions with my staff or members of my litigation team, all go into my assessment on how much preparation they might need. And some of them, right at the outset, hey, this is a sharp individual. He's used to speaking. She's used to speaking. She's comfortable in her own skin. And they don't have an issue saying what they need to say, whether it's supporting my client or whether it's the client themselves supporting themselves. And when it comes to clients, you really have to focus on them from the lens of not only your standpoint as their attorney, but what is the military panel seeing? Or if it's a judge alone case, what is the judge seeing, right? How are they perceiving this individual? So not only are you looking at it through your own lens, but you're going to be looking at it through the lens of the individuals that you're advocating to. And that's the same with witnesses as well, that are fact witnesses that are supporting your client in your case. How are they going to be perceived? What are the motivations of their testimony? Is there a natural bias there because they're a family member or they're a best friend? So we have to analyze all of those things to determine if they should take the stand, and if they do, how do we wall off those biases? What do we do to take out the sting of a potential cross-examination on those things?
Well, let's touch on, you just jumped into the follow up beautifully. Let's touch on the cross examination part of it. So there's the witness prep about the facts, and then there's, hey, what the cross examination is going to look like. In your experience, how much of effective witness preparation is about preparing them for the facts versus when they're getting pushed by the government?
So preparing them for the facts, first, the attorney has to master the facts. Second, you have to make sure that what the individual is saying is consistent with the overall narrative, because if it isn't, they shouldn't take the stand, period. Facts should be easy. Facts are static, okay? What we do with the facts in advocacy is what we do with them, but facts in and of themselves do not change. So then the perception of those facts is what we have to be focused on when we're prepping a witness. So if it's a client, what I try to do, well, not what I try to do, what I actually do is I anticipate what the questions are going to be. I used to be a prosecutor, and also as a defense counsel, I pride myself on the ability of looking at a case objectively. How are both sides going to see this? What are the pressure points? And then it's withering preparation with the client. I am not easy on them. I give them the worst case scenario when it comes to cross examination. And oftentimes that happens early through, and they don't even know it's happening. They don't even know that I'm preparing them for cross examination by the way that I ask them questions, by the way I poke and prod at their story and what they're telling me. But oftentimes, I will heat things up in the way I ask the questions and the tone of voice that I use. And then sometimes it's also knowing who you're going up against. So who are the counsel that are going to be cross-examining them? What is their cross-examination style? I get intel on my opposition. I want to know exactly how they're going to approach my client based off of how they approached other people. So you can anticipate based off of your own client's statements or based off of your witnesses' statements, how they may be exposed through cross-examination. And then there's things that you can do to wall that off on direct examination to draw out the sting. But also, some people cross-examine a certain type of way, vice a different type of way. Some are hyper-aggressive, or some are very subtle. And so that affects your preparation as well. And obviously, the intelligence of your witness matters. How experienced are they in life? I've put clients on the stand that are, or witnesses as well, on the stand that are not terribly bright. Okay, they're not intelligent at all. But what they are is truthful. And it is abundantly clear that they're truthful. And that's what you want. You want somebody that's going to take the stand and just be truthful. You don't even have to worry about what their cross-examination looks like, because they are going to tell the unvarnished truth. That's oftentimes the easiest witness to put on the stand, because the hyper-intelligent witness may overthink the question, or they may decide that they want to take it a different direction based off all the preparation you do. And so it's incumbent upon the attorney to identify that this is a hyper intelligent witness and let them know the pitfalls of going outside the bounds of the preparation that we have worked so hard on.
You know, Joseph, you and I are sports guys, as people can see in our backgrounds with our sports teams. And athletes, they rehearse under stress, right? So they don't fall apart on game day. So, as you're talking about all this witness preparation, like what's the equivalent of that as it looks like for when you're preparing the witness, like you just mentioned, right? It's going to be a tough line of questioning. Here's what to expect from cross examination, but also like similar to athletes, right? In football, they maybe script the first 12 plays. So, like, what does that kind of look like? What's the equivalent in your world?
So for us, it does start with the direct examination of the witness, and that is scripted. And then for cross examination, it is a careful analysis of the weak points of your own case. And where we are particularly skilled at is developing that direct examination in such a way that cross examination is extraordinarily difficult on the prosecutor. That's where we are extraordinarily skilled at. But there are going to be times where you cannot prevent a scathing cross. And so it is reps. You scathingly cross them yourself. And so I'm rough on my clients. I don't hold anything back. I let them have it with both barrels. And I come at them with very aggressive cross examination and in your face cross examination. And then I also come at them with a subtle cross examination. And it's not just me that does it. I get my staff involved. I get my litigation team involved. I get my experts involved. I want everybody that can help the team get us across the goal line to put the client or put the witness through the crucible so that they are thoroughly prepared. The separations and the preparation and what you do on the practice field speaks volume in what you're going to do on game day. Okay. And that is what matters, is that preparation to ensure that you have walled off any particular issues, that you've anticipated everything that could possibly happen. And there's going to be things that you miss. And that's where your experience comes into play to say, okay, well, I can deal with that. I can deal with this. I can deal with this other thing that comes up.
Joseph, in a previous episode, I asked you to share, a kind of client example or something that happened recently in a case. So along those lines, without naming obviously any names, can you share a moment where maybe a witness you worked with, maybe they started off shaky, right? But that preparation starts to kick in and it became one of the strongest parts of the defense. Like what changed during that process for your client or for the witness?
Sure. I had an Air Force case at Keesler Air Force Base some years back. It was a 9-victim sex assault case. And my client was a doctor accused of sexually assaulting his patients. And we knew at the outset that he was going to need a lot of work. And so it was just sitting down and careful preparation. And we had to, everybody has different personalities, right? That's the spice of life, right? So getting to know them and getting them to know you such that they would trust you in the situation that they were in. And this was a unique situation where this individual had been in a heterosexual relationship his whole life. He'd been married, had 6 daughters. And I got on the ground to prep this case about 3 weeks in advance. The case was docketed for 2 weeks. So I wanted to get in early and start prepping on the ground. We do that where we can, when time affords it, clients can afford it, that sort of thing. So it wasn't until about, I get on the ground on Sunday, we're prepping for 3 days, and I had put it in my schedule. I was going to fly home for my son's birthday. He was turning, I think he was turning 4 or 5. And that Thursday afternoon, we found out something earth-shattering about our client, and that's that he was a homosexual. And we're like, holy cow, well, this is our defense. Like, there's no way that he sexually assaulted his patients. We had other areas that we were working on. I had thoroughly examined every single one of these alleged victims. I knew exactly how we were going to cross them. But the linchpin is going to be putting the doctor on the stand to testify about this, because if he doesn't, the panel might think he's hiding something. He's an officer, he's a doctor, he's a person of trust. So we knew that we needed to thoroughly prep him and that he should likely take the stand. And when we found out about that, we had to go through a lot of mental gymnastics with him, with us, to say, all right, you got to embrace this. And we found out that a couple of his older daughters already knew, and his wife knew. And so, it really changed things for the better for him. And once he was able to come out with his truth, preparation was easy.
Right. Well, as we wrap on this episode, Joseph, for the listener out there, they don't see what happens behind the scenes. What would you want to leave them with in terms of what they should understand about the amount of time and strategy that goes into preparing witnesses before you even step foot in that courtroom?
It's vital. You don't want an attorney that comes to the courtroom and is unprepared, is crafting their questions on the fly at the desk as he's listening to the witness. If they haven't taken the time, I don't know. I want to say when I look at a court martial, I always budget 60 hours for the court itself, right? 10-hour days in court. Oftentimes it's more than that. But when I'm thinking about fees and how much time I'm going to put into something, 60 hours for a 5-day court. That's what I budget. So what does that mean in preparation? I'm usually looking at 120 hours. So um, at the very least, that's document review, that is witness preparation, that is consultation with experts, that is interviews, and then sitting down and doing the nug work of prepping the witnesses. And it's not just prepping the witnesses, but it's also prepping what the potential objections can be to the witnesses. That happens before you walk into the courtroom. It has to, so that you can be ready to, on a dime, answer whatever that objection really and truly is. So that all has to happen before you walk into the courtroom. Doing the case law research, because it may be a nuanced objection that you're expecting. And being ready with the case law or the rules of evidence at your fingertips to say, no, judge, take a look. This is what we're trying to do here. So when I'm developing a cross-examination on a witness, I've anticipated what the objections are going to be. When I'm doing a direct examination, I've anticipated what the objections are going to be. I've written in where I think the objection is going to be and what my answer is going to be. That's all done prior to even walking into the courtroom, amongst everything else that we've discussed.
Yeah. Joseph, thank you for the time, the insights, and sharing your expertise on all this. I truly appreciate it, my friend.
Happy to do so, Mike. Thank you.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now. Visit jordanucmjlaw.com. Also, don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.